Good afternoon. Thank you for coming to Advanced Planning, Succession Planning, and Guardianship. And I'm going to hand off to Ann John.
Thank you, Joan. I am joined by two esteemed panelists that I'm just thrilled to present alongside. And I know that this will be a session that all of you will enjoy. And we invite all of you to please join us, and we look forward to questions. We will take them throughout so that if there is something that is of importance enough that you feel a question needs to be asked, it's important enough for the rest of the room to hear as well. So we look forward to hearing from all of you as we proceed. I just want to take a few minutes to introduce our panelists and to thank them. I'm Ann John. By the way, I practice in Fayette County. I'm a member of the Advisory Council, and I'm honored to be in that position. And I'm honored to stand here today and to present this important topic. Along with, I'll start with Judge immediately to my right, the Honorable Theodore Fritsch. C. Theodore Fritsch Jr. is Administrative Judge of Bucks County Orphans Court. Judge Fritsch has been the administrative judge of the Orphans Court of Bucks County since 2007. He's been on the bench for 21 years, and before joining the Bucks County bench in 2004, he was a partner in the Langhorne law firm of Wood and Flogi. From 1986 to 2001, Judge Fritsch served as the Chief Deputy District Attorney in Bucks County. He frequently serves as a panel member and a presenter for the Pennsylvania Bar Institute, which is the continuing legal education arm of the Pennsylvania Bar Association. He presents at continuing legal education seminars frequently. He is a past president of the Bucks County Inns of Court, and he received his JD degree from the Dickinson School of Law. So please join me in welcoming and thanking Judge Fritsch for his participation today. We are also joined by an established and esteemed practitioner, Allison Smith. Allison is to my far right, and she is of counsel at McNeese, Wallace, and Nurick, LLC, Pittsburgh's office. Before she joined McNeese Wallace, she was chief counsel at PNC Bank. In that capacity, she served in the areas of legal support for the bank's asset management group, legal matters relating to administration of estates and trusts, charitable trusts, and endowment and fiduciary liability. With McNeese, she practices in the areas of estate and trust administration, fiduciary liability, estate planning, and charitable organizations. And she has a wealth of practice experience in a broad range of these areas that is invaluable to this panel today. She received her JD from the Duquesne University School of Law and her BA summa cum laude from the University of Tennessee. Please join me in welcoming Allison Smith to the panel. We're going to start with the need for advanced planning. And it is something that I ask all of you to give serious consideration to the question of why does my client, why does the person that I am serving, why does that person need to consider advanced planning? We're hoping that you'll come away from this session today with some very thoughtful considerations on that topic. Advanced planning, succession planning, and guardianships. The intersection of those concepts is vitally important to the areas where all of us work and where all of us spend hours and energy serving those who need it the most. And that's probably the thought I would most like you to consider as we begin the session, because we heard Judge Murphy this morning talking about the dignity of the individuals. And the dignity and the respect for all of these individuals is at the forefront of our work in this area. Everyone deserves to be treated with dignity and respect, and it's something that when we think about how we can use the tools of advanced planning, that dignity plays a very large role. One of the tools, of course, is a power of attorney. One of the tools is an advance directive for health care. When we think about these tools and the reason they are important, we move on to the next question of not only what are they and why are they important, but how can they be implemented? How can we facilitate that implementation? And most importantly, how can the older adults that we are serving gain access to these tools? We're hoping that today you'll get some thoughts for those questions, because access to the tools is of vital importance to maintaining that dignity. So some of the tools are durable powers of attorney, financial powers of attorney, advance directives for healthcare from a medical standpoint, and advance directives for mental health care, living wills, healthcare representatives, out-of-hospital non-resuscitation, the mental health care declaration, and the mental health care power of attorney are among the tools that we will discuss today. Again, how do we provide access to the tools? Those of you who are lawyers in the room, legal representation. Those of you who are social workers or guardians, those of you who serve in those roles, community resources, family support, and pro bono programs play into all of our work. And one of the things that I think is most important, and I'm anxious to hear your thoughts as well, consumer education. And the reason it's at the bottom of the list is so that we can spend just a few moments talking about the need for consumer education. Give it a little bit of thought now. I want to come back to it. I'm going to turn it over to Allison to start talking about powers of attorney here in a moment. But I want everyone to get some of these thoughts into a formulation where we can discuss, or you can at least ask questions if that's how you prefer to do it. Because educating clients, family members, everyone who comes into contact with the legal system, the guardianship system, and of course the healthcare system. Educating everyone is the first step to implementing the tools. So, thank you. So, you're going to lay the groundwork for powers of attorney, healthcare declarations, living wills, advance directives. You're going to lay that groundwork while the individual has the capacity to do so. And it's important, and I know we all know this. I know I'm not telling you something new, but I like to emphasize the fact that when a client is sitting in front of me and they say, why do I need an advance directive for healthcare? I'm fine. Or why do I need a power of attorney? I'm in wonderful health. No one will ever need to manage my financial matters. Well, my response in part, is you're making these decisions now while it's your decision. You're maintaining your dignity because you are stating your wishes. This is what you want, not what I want or someone else wants. You're telling them, this is what I want, while you have the capacity to do so. And one thing to consider is where you are discussing with the elders. Are you in a law office? Are you in a law clinic? Are you in a medical facility? Are you working with the medical professionals? You may take a different approach with a longtime client or a new client. But you want to make sure that the individual conveys their plan to those individuals who need to know. And that's one of the important things that folks need to realize, is that when they walk out of the office with that power of attorney or that advance directive, those documents, while the originals should go into a safe and should be properly protected, they also need to be understood by the individuals who need to know them. And of course, we will tailor the plan to each elder's situation and needs. And we need to understand, and they need to understand, what asset ownership and their financial situation involves. And last, of course, unfortunately, litigation occurs. And I know Judge Fritsch will be talking about some situations that involve litigation. And with that, we're going to move on to powers of attorney. And Allison, I will turn it over to you.
Thanks, Anne. And actually, before I start talking about powers of attorney, I want to follow up on something Anne said about access and giving people dignity and respect. And I know some of the people in this room and a lot of the attendees at the summit often are encountering people who may be indigent or have low income and therefore need more support than your typical person from a financial standpoint, because perhaps they cannot afford to go to a lawyer and have these documents prepared. So as the chair of the Pennsylvania Bar Association's Real Property and Probate Trust Section Pro Bono Committee, I work a lot with legal services organizations to develop clinics where individuals can come and get these documents prepared for them at no charge. And when you mentioned, Anne, you considering where are you meeting with the person, what I hear from a lot of these legal services organizations is that the pro bono clinics that we do not only provide the service and provide the documents and enable their constituents to engage in this planning, but it's also more likely that they will come because these clinics are in community centers. They're in venues and places and environments that the clients are comfortable with, and therefore they're more willing to come and sit down and make these decisions and have the difficult conversations that are required in order for these documents to be drafted and for these plans to be implemented. And I just think that pro bono element is really critical in this particular population. And also it just, I think, furthers the fact that you're treating people with respect and dignity because you're meeting them where they need to be met in literal terms in order so that you can help assist with getting these documents prepared. So that's just a shout out for any lawyers in the room who are looking for pro bono work. There's a lot of opportunities. There's a ton of need. And if you're in, if you're in a profession or in a role that you're looking for resources for clients to get these documents done, there's opportunities out there for you to find pro bono services.
If I may just very briefly, Allison is far too modest. She is the driving force behind pro bono clinics that have been conducted across the state, in Philadelphia, in Pittsburgh at the Duquesne School of Law, many places. And again, the outreach to individuals that Allison has facilitated by driving these clinics can't be understated. So I'm actually going to ask if we could give her a round of applause.
Thank you.
I won't interrupt again.
No, thank you, Ann. And I think we get clients that come into these clinics and they say exactly what Ann just said. Why do I need these documents? I don't have anything. I have very modest means. And it's those individuals who, especially the powers of attorney, both the healthcare and the financial powers of attorney, are critical for, because they need someone to help make those decisions for them when the time comes. Their will, I mean, we still do wills for them because they still need a will. They, may ultimately have property in the future that they don't have now that needs to be disposed of. And I'm very much the poster child for everyone needs a will. But the powers of attorney and the healthcare powers of attorney in particular are that much more essential because they are likely to need assistance in the future, and they'll have the documents. And to your point, Anne, the dignity of giving someone the opportunity to make those decisions now while they have a voice in it, they are so immensely grateful for it. And it just makes it makes your day as a lawyer to actually feel like you're doing something good and actually making a difference in someone's life. So with that, I will stop talking about pro bono and go on to powers of attorney. So I think everybody probably understands what a power of attorney is, but I'm just going to throw it out there because we as lawyers use some technical terms sometimes, and they're not always the easiest terms to use and understand and explain to lay people as well. But a power of attorney, it's a written document. It's where the person, we call them the principal, the client, the constituent, the person who is receiving services from your organization, they use a written document to appoint someone, and that person they appoint is called an agent to engage in financial transactions and to make financial decisions on their behalf in the event of their incapacity. And there are two different types of powers of attorney. They are springing power, what we call springing power of attorney, which is a power of attorney that takes effect upon the occurrence of a specific event. And then there's a power of attorney that takes effect immediately. And the idea is that the power of attorney would be used only in the event that the person, the principal, can't make decisions on their own or can't make their own decisions. But the question that we sometimes get when we draft powers of attorney for people is, well, if I do a power of attorney that's effective immediately, what if my daughter or my son wants to go out and do something that I don't agree with? What if they want to go out and buy something that I don't think they should buy, or I don't want them to buy on my behalf? My preference as a practitioner is to draft powers of attorney that aren't springing, but that do take effect immediately. And I'll tell you why. It's because if they're springing powers of attorney, which means they're contingent upon some specific event occurring, well, then you have to prove that that event has occurred in order for the power of attorney to be effective. And if it's an urgent situation or an emergency, and somebody has to go through the hoops of showing that the person isn't capable of managing their own affairs, it delays their ability to exercise their authority. And secondly, if they don't have the authority yet, because the power of attorney is a springing power, they're not going to get a medical provider or anybody with knowledge of the person's affairs to release information to them that they might need in order to establish that the event triggering the effectiveness of the power of attorney has in fact occurred. So when people ask me the question about, well, what if so-and-so, who is my agent, does something that I don't want them to do? Well, my answer to that is, then you've chosen the wrong agent to act for you under your power of attorney. And I sort of went out of order, and I apologize, Anne, but that's why choosing the agent, choosing the person who is going to exercise those powers for the principal is the single most important decision they're going to make when it comes to executing a power of attorney. And obviously it should be someone who's trustworthy. It should be somebody who knows the person, understands their assets, understands their financial situation, and it should be somebody who is capable of fulfilling the fiduciary duties that are required of them. So that means keeping good records, keeping the principal's assets separate and apart from their own assets, and following the requirements that the statutory provisions of our Pennsylvania Power of Attorney Act impose upon the fiduciary.
I'm going to jump in if you don't mind. And you're talking about the need to find someone who is trustworthy, Unfortunately, and we would all agree, we all absolutely know that that is vital. That's the first thing you need to think about. Unfortunately, as we all know, situations have occurred where misuse has happened. And the person that the principal believed was truly trustworthy turned out not to be quite so trustworthy. And in those situations, litigation takes place and the courts step in. And people like Judge Fritsch, who has a wealth of experience and wisdom, step into those situations. Tell us about that,
Well,
please.
obviously, I see litigation where there is either no advanced planning, where there is poor advanced planning, or where there is untimely advanced planning. As Allison and Ann were talking about, it's very important to choose the right agent in a power of attorney situation. Oftentimes, agents are dependent adult children, and that is not a good situation. Oftentimes, it can lead to abuse if someone is not financially or residentially stable. They obviously then would have a motive to take advantage of a power of attorney instrument. Again, as far as timely planning with respect to powers of attorney, ideally, you don't want to wait until a person is, let's say, 88 years old and may have a dementia diagnosis 6 months later. You want to try to have people, again, who are of totally sound mind, perhaps in their 60s or 70s, making these decisions with respect to powers of attorney, and not people who are already declining. And then, of course, the lack of a power of attorney or advanced planning instrument can obviously lead to litigation if you have family members fighting over control of an older adult or over their money, for instance. So again, good advanced planning can really forestall litigation and avoid it. So it's critical that that be done timely, that an agent be picked who is trustworthy, as Allison said, and certainly is stable financially. Again, it's important to make sure that that document is in place at the right time.
Thank you, Judge. When an agent is appointed, they have certain powers. And I know that Allison is going to talk about some of those powers and something called hot powers, which we're all interested in learning more about. So please, Allison, tell us about the agent's powers.
Sure. And before I go on to that, I want to just make one more note. Sometimes the clients will want two agents or multiple agents to act on their behalf. And the consideration you have to give there is, do the two agents get along? How practical and feasible is it that you are going to get two signatures or sign-offs or consents that you need when a decision needs to be made? So ultimately, it's the client's decision. As a lawyer, we just explain to them the risks and the downsides of one versus the other. But most, I think, clients that I see will choose, if they do choose two people to serve as their agents, we will include language in their power of attorney that enables either one of them to act alone if consultation with the other is not feasible. And then, of course, we are trying to always plan for every contingency. So naming one agent isn't enough. They should consider naming a backup, because you never know what will happen with the first named agent. And if they only name one agent and don't have a successor, then the power of attorney is as good as nothing. There's no effect anymore, and then you're back in a situation of needing to have a guardianship. But yeah, let's talk a little bit about the powers. So the scope of the power of attorney in terms of the powers it gives to the agent can be as broad or as limited as the client desires. In Pennsylvania, the Power of Attorney Act that we have has certain defined powers that are defined in the statute. So if you use the language, if you use the phrases that are in the statute, you don't have to write paragraphs worth of what that means. So for example, common powers that would be included in a power of attorney are like banking transactions, real estate transactions, personal property transactions, and all those phrases that you see oftentimes used in the document are in fact defined in the Power of Attorney Act. There are certain types of powers, and those are the ones that we call hot powers, that in order for the agent to have the authority to exercise those powers, they must be expressly included in the power of attorney. And they're significant powers because they give the agent very broad authority to take certain action that may be contrary to what the client or the principal has put in place prior to the agent acting under the power of attorney. What are some examples of the hot powers? So the power to change a beneficiary designation, whether it's an IRA, a 401k, a life insurance. So in order for the agent to have authority to change a beneficiary designation, that power must be expressly granted in the power of attorney. And a catch-all power, so something that says my agent shall have every power that I could exercise if I were present and able to exercise it myself, that's not good enough. That is not good enough to incorporate a power to change a beneficiary designation. It must expressly say that. And I know there's been a lot of talk and discussion, and I was a panelist on another session involving financial institutions and sometimes the frustration that comes with financial institutions. But that is one of the things that a financial institution is going to review when a power of attorney is presented to them for review, and they're going to look to see, does it contain the language that allows the agent to change a beneficiary designation? Because the client may have a CD at the bank that says, Joe Smith, POD, TOD, which means payable on death or transfer on death, to Susan Smith. And if the power of attorney doesn't contain a specific language that allows the agent to change that beneficiary designation, then the bank should not be allowing the agent to change the title on that CD. Similarly, a power of attorney must contain the express power to change rights of survivorship or create rights of survivorship. So that's typically something that occurs or arises in the context of a joint bank account. So Joe Smith has a joint bank account, just his name. His agent is his son, Bob Smith. Bob goes into the bank and says, I want you to add me to this account. So the financial institution should be looking at that power of attorney and say, well, what does that mean to add him to the account? The agent should be added as an authorized person to receive statements, to write checks, to make deposits. But if the power of attorney does not expressly allow the agent to create or change rights of survivorship, then they shouldn't be able to add themselves as a joint owner to the account. And that's where sometimes the frustration arises with financial institutions, because the client or the customer of the bank is going in and asking for something, and they don't really understand what they're asking for. And the financial institution, hopefully knows the rules and knows that there are limitations on what the person can do, even though they are the agent under the power of attorney. So those are some examples of hot powers that must be expressly stated in the power of attorney in order for the agent to have that authority.
Allison, let's jump off of the PowerPoint for a moment and compare that to the provision in the Probate Estate and Fiduciary Code. For those of you who aren't familiar with what we often call the PEF Code, is found at Title 20 of the Pennsylvania statutes. And it contains the chapters that address each of these. So in Chapter 55, which is, of course, incapacitated persons, so it deals with guardianships, there's a provision in there Section 5536, titled Distributions of Income and Principal During Incapacity. But if you read down to subsection B, it talks about estate plan. And Allison was just explaining that hot powers, so to speak, can be addressed in the power of attorney if they are specifically delineated. But with a guardianship, a court order is required to undertake certain actions. And Allison, I don't know if you or Judge Fritsch would care to address it, or if you'd rather hear me read.
Well, I will just say that if a guardian is appointed for someone, that guardian may apply to the court for permission to estate plan for the ward. And it's quite unusual for that to happen. I've only had such petitions in front of me on a few occasions over a lot of years, but it can be important. One situation I had was a situation where, unfortunately, a young adult who was under guardianship, his mother was guardian, was dying. He didn't have any testamentary documents or anything of that sort or directives. And if he were to die intestate, his estate would go equally to his parents. His mother had taken care of him his whole life. His father had abandoned the family when he was 5 years old. So again, there was a real unfairness that was going to occur if I did not let the guardian or an attorney hired by the guardian estate plan for this young man, so that when he did pass away, his assets, which did consist basically of trust assets, would go to his mother rather than to his mother and father equally. So we had a hearing on the issue. Fortunately, in this case, the father was tracked down. He actually came to the hearing, and after a little bit of cajoling by the attorneys and so forth, decided, well, it isn't fair for me to inherit half of the estate, and I granted authority for someone to estate plan for the young man so that things were done more fairly. So that's just an example of estate planning for someone who's under guardianship to prevent an injustice occurring.
And that's an excellent example, Judge. Trusts are an important planning tool that, again, unfortunately, we don't have time to get into those today, but they are a very important consideration in advanced planning. Allison and was just talking about the potential for misuse, and you know, what happens not only if a person has a situation such as that, but what if a person doesn't have a power of attorney at all? There's an opportunity for financial exploitation there as well. And so it's not just misuse of the tool, it's misuse of the situation that can occur if you don't have the tool. So do you want to tell us a bit about what happens if there's no power of attorney?
Sure. So if the person doesn't have a power of attorney and they become incapacitated, then the only option to obtain control and to have someone appointed to exercise authority on behalf of that person is to go to court and seek a guardianship. Now, it may not be a full plenary guardianship. As we know, with Act 61, there's a requirement to consider less onerous or alternative methods beyond a full plenary guardianship. But ultimately, if a guardianship is established for that incapacitated individual, the court, of course, will have ongoing supervision and oversight. Any principal expenditures from the guardian's estate will require court approval. As we already said, an estate plan would require court approval. Pretty much anything that requires a legal decision beyond the disbursement of the income that is being received into the guardianship estate is going to require court approval. I think the guardianship staff in the orphans courts that I deal with on a regular basis are phenomenal, and they certainly go above and beyond to create processes and procedures and forms to make it less onerous for the guardian to comply and to get the approvals that they need. But obviously, from time to time, they're going to need counsel. Counsel costs money. So it can result in significantly higher costs ultimately to the client than the preparation of a power of attorney. So, and it's more time consuming. If you need to go to court to get approval to sell a house, enter into a contract, that's going to take a lot more time than simply exercising that authority under the power of attorney. And I'll just wrap up. If you want to jump to slide 15.
Sure.
And I'll just wrap up with just sort of an overview. From a power of attorney perspective, you know, what you want to be careful of is that the power of attorney complies with all legal requirements. So in Pennsylvania, it has to be notarized. There has to be 2 witnesses. It has to contain a notice on the front to the principal advising them of the effect and consequences of signing the power of attorney. The agent must sign an acknowledgement. So they don't have to sign it when the power of attorney is created, but under the statute, in order for the agent to have authority, they must first sign that acknowledgement, acknowledging what their responsibility is as an agent and acknowledging that they will undertake their fiduciary duties in compliance with Pennsylvania law. Try to make sure there's a successor agent named, as we discussed earlier. If there are specific powers that need to be included, whether it's gifting, whether it's in, retirement accounts, I mean, that's obviously a big one when it comes to beneficiary designations, then make sure that's included. And then make sure that whoever it is who's the client understands the scope of the power of attorney and understands what limitations that it may have. One common one is trusts. Typically, an agent under a power of attorney is not going to have the authority to step in as trustee, for example. So if a client has a revocable living trust that they've created and they've named theirself as the trustee, unless the power of attorney expressly grants the agent the authority to act as trustee, the agent's not going to have any authority over that trust. The trust agreement's going to control. It's going to say if Joe Smith can't serve as trustee, then Susan Smith will serve. And if the agent is Charlie Smith doesn't jump over Susan Smith into the shoes of the trustee. The trust agreement is going to control that. So again, that's more probably detailed than is within the scope of this particular session, but just something to be aware of. If you see a power of attorney in a trust, you need to stop and say, does this really apply?
Thank you, Allison.
Sure. Thank you.
Let's talk a bit. Judge Fritsch, I know you have some thoughts on.
Well, the kind of power of attorney litigation that I see, of course, are petitions for accountings when someone discovers that there may have been some improprieties. Petitions to remove agents also are somewhat common, or declaratory relief petitions seeking to terminate the power of attorney, essentially. So those are ways that cases get before me. I recently had an interesting case involving the use of a power of attorney, where a second wife and husband owned a marital residence. For some reason, they put the residence into a revocable trust. Under the terms of the trust, upon the death of one of the spouses, the other spouse would get a life estate in the property, and upon the death of the surviving spouse, the property would be divided evenly. The proceeds from the sale of the property would be divided evenly between the husband's children from his first marriage and the wife's children also from the first marriage. So this is the way the trust was set up. The trust was also set up, it had an interesting provision that indicated and dictated that the husband would have to consent to removing the property from the trust and terminating the trust. What happened was the husband became mentally disabled. As he was declining, his wife became agent under a power of attorney for him. Wife also, I didn't mention, was settlor and trustee of the trust. And then after wife had power of attorney, she, as power of attorney, signed a consent on her husband's behalf to take the property out of the trust, thereby essentially cutting off his children from the inheritance with respect to the proceeds of the house. So again, the question, of course, initial question is, does the trust have hot powers permitting her to do that? There is some question as to whether she should have even been trustee and power of attorney agent at the same time. But that's what can happen when powers of attorney go wrong, and it can really kind of tear up a family and cause a lot of discord. So that's just an example of kind of a power of attorney being used perhaps improperly and also affecting a irrevocable trust.
Judge, you just raised a point, and I'm looking at our time, and I see the odds of our getting all the way to slide 52, we're at 16, are not real good.
Sorry.
So, the reason, I want to thank you. Don't be sorry, because you gave me an opportunity to throw something out that I know we won't get to, but what you've done is you've given me a chance to bring up the ethical considerations in all of this, because the entire planning puzzle involves so many issues that are ripe for conflicts of interest, for considerations involving clients with diminished capacity. So I invite all of you to look at the slides at the end as well that talk about how attorneys can deal with clients with diminished capacity and what the ethical obligations under the rules of professional conduct are, and what the obligations to the clients are. Look at not only the rules of professional conduct that are cited in here, but also the comments to those rules. The comments are invaluable. So thank you, Judge, for giving me a chance to jump ahead. And having done that, I think we can move on and spend a bit of time on advance directives and healthcare representatives, if that's okay. And Judge, I want to give you an opportunity to talk about a situation involving end-of-life decision-making that I know our audience will be very interested in. I'll give just a brief overview first, if that's okay.
Sure.
So I'm going to jump ahead again. And I keep pointing at the screen. I should be pointing at the computer. Okay, so healthcare agents and representatives act as part of a larger statutory scheme. And what that statutory scheme recognizes is a qualified right of individuals to make decisions related to their own healthcare. And it establishes a framework for substitute healthcare decision-making for those persons who are unable to do so. Again, we go back to the beginning of the session where we talked about the fact that we are asking these individuals, do you want to make these determinations and decisions? Do you want to provide for it now while you have the capacity to do so? So the two objectives, appointing a healthcare agent, which is the healthcare power of attorney, and providing guidance for end-of-life care, the living will. So those are the two primary objectives, and then we can get into some of the details of them. But what happens when there is no planning and there is end-of-life decision-making that needs to be, sadly, engaged in?
Yes, well, I recently had a case concerning end-of-life issues, and the situation was that a woman, not that elderly, I think in her 70s, had some serious surgery. After she went home following the surgery, she was in a weakened condition. She fell at her house, hit her head, became comatose, and remained in that state for the rest of her life. Her daughter filed a petition. There were no healthcare directives. Her daughter filed a petition to withdraw heroic life-saving report and change her code to DNR, filed a petition with the court. We had a hearing. Daughter called 2 doctors to testify that she was in a permanent vegetative state. The woman's son objected, indicated that he wanted an opportunity to perhaps obtain another doctor to testify. So the case was continued after the first hearing. We had another hearing. Son wasn't able, for some reason, to get another doctor to give an opinion. I appointed counsel for the person who was comatose and directed her to try to see if she could find an independent or another doctor who was not a treating doctor to see if he or she had a different opinion. She hired a doctor who indicated that he also thought that the mother was in a permanent vegetative state. So based upon that, I granted the petition. The son appealed to the Superior Court. The Superior Court, after several months, affirmed me, and the daughter then tried to have life support removed from mother. Son advised the hospital that he had finally found a doctor who thought that that shouldn't be done. So we had another hearing, even though I had been affirmed. The doctor hired by the son, said, well, and a very highly respected neurologist said, well, I will give the mother, I would give the mother, if I was her treating physician, another 2 or 3 months to see if she recovered from that state, and then I would consider palliative care. So we, based upon that, I stayed my order granting the daughter authority. We let 3 months go by. We had another hearing. Mother didn't improve to any great extent. More doctors testified. The son's doctor testified that, well, I might give her a few more months, but he had not really seen her and just did that based on reports. So I withdrew the stay. The son appealed from that order, withdrawing the stay, went back to the Superior Court. Finally, the Superior Court then affirmed me again, and the sister then was permitted to withdraw life support. But this entire process took 2 appeals and a whole year, basically. So that's what can happen if there isn't a healthcare directive or a living will or an agent. So it was just a battle between son and daughter that lasted basically an entire year. So I'll stop.
No, please don't. Please continue, because it's so important that our clients and the elders that we serve understand, and this is where it goes back to education, that as long as they have someone that they believe to be trustworthy, Allison's comments about financial powers of attorney apply equally to advance directives and healthcare powers of attorney and a healthcare agent. It absolutely has to be someone trustworthy, someone who has the ability to act. The daughter was local,
Yes.
close by, and that makes a huge difference. She can talk to the doctor, person to person. The ability to have successor agents if necessary. All of these considerations equally go into the advance directive. And some of the things that a healthcare agent, some of the powers that a healthcare agent has can include medical care and surgical procedures, nutrition, hydration. You can go on down through the list, but all of those matters. This individual, it's heartbreaking to hear these stories and to hear of family discord that potentially could have been avoided if she had expressed her wishes while she had the capacity to do so.
And you know, the statute attempts to close the gap. There's a provision 5461 that designates who can serve as a healthcare representative for someone if they haven't previously designated an agent under a healthcare power of attorney. But it also allows somebody to just designate a healthcare representative, which doesn't require the same level of writing and formality that a healthcare power of attorney does. And that statute basically says that someone that is designated as a healthcare representative has the same powers as a healthcare agent under a healthcare power of attorney. It also gives the pecking order, so to speak, for the people who by default are the healthcare representatives if somebody hasn't appointed one. Now, in Judge Fritsch's situation, the statute didn't help because the first is a spouse, unless you're in the process of a divorce, and the second is the adult children. So the two contesting persons in the case that he had both had equal priority under the healthcare representative statute under the default provision. But again, just shows that if this particular person had been able just to simply designate a healthcare representative, then the doctors and the medical providers would have had to listen to the daughter in that instance if that's who she had designated, and the son wouldn't have had the legal standing. That doesn't mean he wouldn't have tried, but he wouldn't have had the legal standing, or certainly wouldn't have had the equivalent legal standing of the daughter under the applicable act. And under the statute, the ability to designate a healthcare representative is by assigned writing or by personally informing the attending physician or the healthcare provider. So it doesn't even have to be in writing. Personally informing is sufficient.
And Allison, the competency of the person is vital.
Yes.
So they need to be competent. They need to have the capacity when they do that. But I've had clients come in and ask me, and I'm sure you have as well, well, if I sign this, do I lose my ability to then make that decision? And the answer to that is no, not while you are still competent, not while you still have the capacity. And that's part of the statute. The healthcare power of attorney is operative when a copy is provided to the attending physician and the physician determines that the principal is incompetent. So if the physician, the attending physician, and not a physician who hasn't ever seen the individual, is not the attending. So if the attending physician determines that the principal is competent, they can still make their own decisions. And I know that we've talked about the importance of respect and dignity, and all of this again ties in. And oh my, I'm going way over. It's 5:02. We have until 5:10. Am I correct?
Correct.
Okay, thank you. So I'm going to jump. We're at slide 22. We're rolling along. I want to very briefly mention, and you'll see I'm, unfortunately because of time, I'm going to skip over many of the healthcare power of attorney and declaration. I'm going to skip over the living will, who decides for an incapacitated person, because I want to very briefly mention the mental health. And you just saw, by the way, countermand. Obviously, the principal, and we were just talking about that. I'm looking for that in here. So let's move on. Mental health care powers of attorney. We're getting there. Okay.
There you go.
Thank you. All right, mental health advance directives, and there are actually two components here. So if a principal has a healthcare power of attorney, an individual can prepare a mental health care declaration or a mental health care power of attorney, or a combined document. The statute does provide that a combined document may be prepared. Again, the same considerations come into play here, but an important distinction between a mental health care power of attorney and mental health declaration is that persons, am I on the right slide? Let's get to the right slide. Here we go. Persons shall execute or amend their declarations or mental health powers of attorney every 2 years. If a person is incapable of making mental health care decisions at the time the document would expire, the document shall remain in effect and be reviewed at the time the person regains capacity. That is a very important distinction between these tools and financial powers of attorney. Guardianships can go on, or they can be subject to review hearings, as we know. They are subject to review hearings now under Act 61. And Judge, if you want to tell us about that, we're
Well-
happy to hear that, because it's a big distinction.
Certainly, Act 61, of course, encourages review hearings, especially when the facts of the case indicate that there might be improvement or the lack of a need for guardianship in the future. Those are the most fun guardianship hearings I ever hold, when somebody has regained capacity and we can terminate the guardianship. Those are really joyful occasions, and fortunately that does happen from time to time, especially if people are, let's say, have suffered a brain injury and have recovered. Also in the mental health area, people sometimes, once they get on medication and therapy, they can make tremendous strides. So again, review hearings are often, again, very rewarding hearings to have, and it's always nice to see people regain capacity. I will mention that in guardianship court in the past 5 or 10 years, it seems that we have more and more people coming through who are seriously mentally ill, have psychosis and so forth. And I'm not quite sure why that is. In my first years on the bench, generally, I was dealing with people suffering from dementia and later life illnesses, but we've had kind of an uptick in mental health cases. But mental health cases are cases where there can be recovery with therapy and medication, and so that is one good thing about them.
Thank you, Judge. And I would point out that the provision dealing with rights and responsibilities in mental health care is Section 5807. I believe the slide said 2807. It's 5807. So we'll correct that. But it's very important to consider all of these factors and how the interplay of them works. We're so short on time. I want all of you to just give thought to the interprofessional collaboration that comes into play here, the dignity and respect that we've talked about for the clients and the elders that we deal with every day, and for all of the factors that go into advanced planning, succession planning, and guardianship. Judge Fritsch and Allison, Judge Fritsch, I'll give you the last word. I'll let Allison give hers, and then please take the last word.
Well, again, as I mentioned at the outset, advanced planning is very important. It keeps you all from getting into court, and which is good for the courts and good for everyone else. So I just certainly encourage good advanced planning and keeping with some of the comments we've made today. So,
Thank you.
And I'll just say that sometimes the client may arrive in the office of the lawyer, and they're already suffering from some cognitive decline. And so the question is, like, what's our duty as the lawyer to determine their capacity? And the rules of professional conduct require that to the extent we can, we should still maintain an attorney-client relationship even with somebody with diminished capacity. As lawyers, we're not medical providers, but back to some of the thoughts that we've had earlier of understanding your client and understanding their needs. Oftentimes, just by having a conversation with the client, you can get a sense of what their capacity is, and to execute a power of attorney or to execute a healthcare power of attorney, they have to understand generally what the purpose of the document is, what the scope of it is, meaning if it's a financial power of attorney, what is the extent of their assets, and then what is the legal effect of the document. So they may not have the capacity to enter into certain legal contracts that a person would normally enter into, but the capacity required to execute one of these documents may not be the same level. It's similar to the capacity required to execute a will, but not exactly the same. And it's, do they have the capacity in that moment when they're executing it to understand what they're doing and why they're doing it and the effect of what they're doing? So that's what I'll leave you all with. So thank you.
Thank you, Allison. And I just want to give a real quick shout out. I know you're all ready, and I'm between you and dinner. Very, very quick shout out. The event was supported by the Administration for Community Living, the U.S. Department of Health and Human Services, as part of a financial assistance award. So this grant is just invaluable. This has been awesome. Joan Bertone is in the back of the room. Please join me in giving her and the entire Office of Elder Justice a huge thank you. And most importantly, to panelists Allison Smith and the Honorable C. Theodore Fritsch Jr. Thank you.